So the curtains are closing on this case, right? We will now look at what the second judge wrote in his opinion about the difference between central management and control and a place of effective management. And the court starts and says, these reasons will explain, under the 2003 UK Convention and the Swiss Agreement, there are two possible avenues of relief, right? First, if the company is resident only of the UK or Switzerland, and second, if the company is resident of both the UK or Switzerland and Australia, but its place of effective management is situated in the UK or Switzerland. And then it says, so here the first avenue turns on whether the company is also a resident of Australia for the purpose of Australian tax law. And for Australian tax law, you need to look at central management and control, because that's what's required by Australian tax law. And then the court says, Chemical Trustee and Darren submitted that the lawfully appointed organs of the companies were not bypassed, and that the effective decisions of the companies were made by the board or its directors, albeit in many cases influenced by Mr. Gould. And then the court just says that contention should be rejected. It is contrary to the finding of fact, not challenged on appeal, that Mr. Gould was a person who controlled Chemical Trustee and Darren. Therefore, each of Chemical Trustee and Darren is a resident of Australia for the purpose of Australian tax law, because its central management and control was in Australia. And what that means is you now have a dual resident company. So you now need to look at the treaty to see if the treaty can save them from Australian taxation. But the court says in an earlier paragraph, it says, Chemical Trustee and Darren focused too closely on the concept of central management control without reference to the specific provisions of the 2003 UK Convention. At the hearing, counsel for Chemical Trustee and Darren submitted that you look to the same matters to determine place of effective management as you do to determine central management and control. But the judge doesn't agree. He says, as the Commissioner acknowledged, in some cases, such as the present, the result may be the same, but as the Commissioner rightly submitted, they are different concepts. The meaning of each turns on the interpretation of the phrase as it appears in the relevant instrument, either Australian law or the treaty. Each must be examined to determine the applicability of each in any given case. It cannot be assumed that if one test is satisfied, then it will automatically follow that the other is satisfied. So the judge goes into a lot of theory here, but then he also looks at what the place of effective management is. And after discussing the Vienna Convention on Law of Treaties and concluding that for Australian legal purposes, the OECD commentaries have the role of additional material, as discussed in Article 32, it then looks at what the OECD commentary says, and it says, during the relevant period, the commentary stated that the place of effective management, therefore Article 44 attaches importance to the place where the company is actually managed, which means the place of effective management is the place where the key management and commercial decisions that are necessary for the conduct of the entity's business are in substance made. The place of effective management will ordinarily be the place where the most senior person or group of persons make its decisions, the place where the actions to be taken by the entity as a whole are determined. However, the commentaries say, no definitive rule can be given, and all relevant facts and circumstances must be examined to determine the place of effective management. So, and from this, the court says, it's fine that you held your board meetings where you say you held them, but that's not where the real decisions were made, right? So the court then goes on. As those passages from the commentary explain, while the place of effective management may ordinarily be with the place where the board of directors make its decisions, all relevant factors and circumstances must be examined. So where was the place of effective management for Chemical Trustee and Darren, Australia or the UK? And the answer is Australia. Indeed, at the hearing, counsel for Chemical Trustee and Darren contended that neither company was managed or controlled in the UK, but each was managed and controlled in Switzerland. Remember, we said that the Borgeses were members of the board and were operating from Switzerland. But the judge disagrees, says the companies were incorporated in the UK, as were their ultimate shareholders. However, both Chemical Trustee and Darren, the board of directors, exercised lawful authority of the company in Switzerland. Critically, though, Mr. Gould was a person who controlled and ultimately owned Chemical Trustee and Darren. The key management and commercial decisions were made by Mr. Gould in Australia. That was the effective place of management. So that was the decision taken under the UK Australian treaty, and then the judges also look at the Australian Swiss treaty, and they say the Swiss treatment, like an agreement like the UK 2003 convention, derives from the Model Convention. However, and this is an interesting point that they bring up about the status of the Vienna Convention on Law of Treaties, it says, unlike the UK Convention, its interpretation is not governed by the VCLT, and that's because Article 4 of the VCLT relevantly provides that it applies only to treaties which are concluded by the states after entering into force of the VCLT. Now, the VCLT did not enter into force with regard to Switzerland until after the conclusion of the Swiss agreement. Nevertheless, the court has recognized consistently that consistently with the international law, Article 31 and 32 of the Vienna Convention on Law of Treaty reflects customary international law, and it is therefore appropriate to undertake the interpretive task by reference to those provisions. So even though the VCLT came into force later, it was just encoding what was already what do you call that? The customary international law, and that was much older than the Australian Swiss treaty. So it then comes to the quite brutal conclusion again of none of the companies had its place of effective management in Switzerland. The primary judge found that Mr. Borges' role was a facade and fake. The primary judge found that Mr. Borges exercised no independent judgment. His position was to do as he was told by Mr. Gould without thought. All that occurred in Switzerland was the formal implementation of decisions that in substance were made by Mr. Gould. On that basis, it is nonsense to say that Mr. Borges was effectively managing each entity from Switzerland. The place of effective management was with Mr. Gould in Australia. And with this, the case is closed, and the companies are deemed to be resident in Australia and taxed on their gains in Australia. What is interesting is, I mean, clearly Mr. Gould was a very successful investor, right? Because these companies ended up being taxed, I think, for capital gains in excess of $320 million, Australian dollars, as far as I know. But that is a lot of money to make through buying and selling shares. So that was the tax cases, but the court went on. I mean, Mr. Gould was prosecuted for tax evasion, and then he was also prosecuted for tampering with a witness, of trying to influence Mr. Borges's witness opinions. And you can see some of it here in some later newspaper articles. We have here from 27 November 2020, Vander Gould goes full Trump, and it talks about Mr. Gould, you can see him at the bottom here, actually suing the Australian Commissioner of Taxation, who he says has for defamation of character. And he's got a whole lot of other lawsuits going on, but he also appealed against his judgment for tax evasion and witness tampering, and on appeal, that sentence actually got increased from 1 year to 6 years. As you can see here, the sentence was overturned, and Mr. Gould was resentenced to a 6-year term of imprisonment with non-parole period of 3 years and 6 months. I mean, the man is 74 years old, so one do feel some sympathy for him. But I will leave it for you to read more about the personal circumstances of Mr. Gould. I will leave some links to newspaper articles in the comments below. And as these cases are still going on, I mean, more news may follow. I hope you enjoyed this case. It is, I think, quite an intriguing case. I think it also deals with some very interesting tax aspects, and I look forward to seeing you at our next decision. Bye for now.